Hi, everyone.
Hi, Carolina. I
Hi,
can see you're here.
Hi. It's so nice to
Hi.
see you.
Likewise, it's good to meet you.
Yes.
Pleased to meet you, Carolina.
Pleased to meet you, Robert.
Yes,
So
just one thing. Since we had a lot of participants joining in, we have decided that they would be attending through the YouTube live so that there's no disturbance to the Zoom session, and the Zoom session would just be open to the guests and the moderators.
Oh,
Just-
wow.
Yes. And yes, since Carolina, you are from CyberRab, you can maybe take us through the potential risks of YouTube live.
So how many people are joining for the Zoom?
So we were very happy when we received around over 300 registrations for this panel discussion, and we're hoping a large number of them would definitely attend this panel discussion as well. So that is the reason we shifted to YouTube Live to avoid any disturbance between the sessions, so that all of the panelists are comfortable also.
Well, that's an extraordinary achievement. So to the organising group, assuming you three are involved heavily, well done.
Thank you, Mr. Heath.
Yes.
Thank you.
Arijit, call me Rob, please.
Ah, all right.
Sounds like you're talking to my dad if you call me Mr. Heath.
It's okay. I'll keep that in mind. Thank you, Robert. We have another one of our panelists joining right now. I can see Mr. Ankush Mehta, who's a partner at Cyril Amarchand Mangaldas with the Mumbai office, has joined us. And sir, we would be beginning with the session shortly, and we are just waiting in for the other panelists to join in.
Ankush, please.
Hi, is the light okay behind, or it's I'm still looking from the dark edges?
I'd say we could have a bit better light if that's
okay. Give me a moment. Does this work better?
Yes, not bad. Yes. Additionally, for a smooth conduct of the panel, we have decided that we would be taking the audience question from the YouTube live towards the end, if that's acceptable to the panelists who are already here so far.
Yes, of course.
So I'm just trying to figure out which is the better place, because there are a few odd angles in the house, unfortunately.
This is a lot better.
This is better? Okay, thank you.
Where are you based, Robert?
I'm in Melbourne, in Australia.
Mm-hmm.
Whereabouts are you? I beg your pardon?
What time is it there?
It is almost 7:30 in the evening.
Okay. Yeah, of course.
Are you in the UK or are you?
Yes, I'm in London.
Yep.
So it's still morning here.
And you're in Mumbai and Kush, I take it. Yep.
Very hot
Yes, the
summer.
days. Sorry.
Very hot summer afternoon, I see.
Mm-hmm.
Excuse my ignorance, but is Pune in Maharashtra too?
Yes.
Yes,
Yeah.
it's about 3 hours from Mumbai.
Yeah.
Yeah, it's 5 hours away from here. For some reason, I thought it would have been more. I don't know. 5 hours doesn't feel that far away.
So in India, currently we are struggling with the heat. It goes for about 45 degrees Celsius every day. It is way too hot in the afternoon, and then we get a little relaxed after 8 o'clock in the evening.
Wow. I wish I had the same problem, honestly. It's still quite cold in here. It's just getting better now, but we're still below 20.
Well, by way of contrast, Sanjana, we've just lit the fire here tonight at home.
Right.
Wow.
Yeah, we're freezing here today.
Wow.
How is Mumbai treating you, Ankush sir? I'm sure you would be able to relate with the heat.
Much born and brought up here, but the lockdown I did spend 2 years in Pune. So I think the heat is similar, except that some places have a lot more dry heat and this is more humidity, and that's the only difference.
I just contacted the other two panelists and they'll be here just in about 3 to 4 minutes. So
Arijit, just to be clear, I'll be going in first as just to give
yes.
Then I can, because I have another session starting at 3:30.
No problem, sir. Bhuvanesh did brief me about it and we have curated the session in a similar way so as to accommodate. Thank you so much.
Some of my colleagues were there yesterday and went off well.
It went quite well. So since all of us were resuming, and as I was just telling Robert and Carolina that we had an in-person session before this, it went quite well now that we are starting to slowly resume with physical events. So yes, it really went well. And I can see one of our other panelists from Frankfurt has joined too. Good evening. Good morning. I apologize. Just a minute more. Our last panelist is just joining us.
I believe Shivangi Sinha is not there. She's out today.
Yes, so we had a session before this, and she was just about to accompany them for the lunch and dropping off some of them at the airport. So yes. Yes, we have a full house now, I guess.
Sorry, I'll just change my name.
Comments.
Good afternoon, sir. So we have all our panelists here for the international panel discussion. This is the last session of the same. I would now like to invite Ms. Shambhavi Shivani to please commence the session.
Good part of the day, everyone. I'm Shambhavi Shivani, a student of New Law College and a member of Madhistata, the ADR cell. First of all, I would like to thank each one of you for joining us for this International Panel Discussion 2022. Madhistata, with the support and guidance of Bharati Vidyapeeth, deemed to be university, and New Law College Pune, organizes such events to enlighten young minds and promote participation of students in ADR. The International Panel Discussion 2022 is based on the theme of international arbitration. This panel discussion is the last session of the two-day event. In today's session, we will be discussing about technology in arbitration, its challenges, avenues, and the road ahead, and will be explored from the global perspective and the changes after the pandemic and the impact of the upcoming robust technologies. Now, on behalf of our principal, I would like to call upon our moderator for this event, Ms. Sanjana Sachdev, who will formally introduce our university and our ADR cell.
On behalf of our principal, I am here to formally introduce you all to our university. The institutions of Bharatiya Vidyapeeth were accorded with the deemed to be university status in 1996. For its academic excellence, Bharatiya Vidyapeeth is accredited with A+ grade in 2017 by NAC and has also been categorized as the first university status by UGC and is ranked 68th by the NIRF. Under the excellent guidance of our beloved patrons, that is Dr. Patang Rao Kadam, Dr. Vishwajit Kadam, Dr. Asmita Jagtap, and Professor Dr. Manik Rao Salunke, our college has been consistently ranked among top law institutions of India by Career 360, The Week, Lawyers Collective, India Today, Education Post, as well as Outlook. I would now like to proceed and introduce our alternate dispute resolution cell, that is Madhyasthata. This cell is a student initiative working efficiently in training and developing the skill sets of the students in the field of alternate dispute resolution by conducting various seminars, webinars, panel discussions, and intra-college competitions. The ADR cell focuses on developing the skills of students and helping them to pursue their career in the field of alternate dispute resolution, and especially trains them for the international modes like William C. International Commercial Arbitration mode. And this year, we are delighted to share that our team was ranked 66th out of the 362 participating teams across the globe. I wholeheartedly again welcome you all on behalf of my principal on this panel discussion today.
Thank you, Ms. Sanjana. Our panelists for today's session have joined us, and now I move forward to introducing them. Our first panelist of the day is Mr. Robert Heath. Mr. Robert Heath is a Queen's Counsel, a Fellow of Chartered Institute of Arbitrators, has a broad practice which encompasses commercial, equity, negligence, and infrastructure disputes. Mr. Robert has substantial trial experience, and his recent work includes an appearance in a lengthy trial of arbitral proceedings concerning the failure of a subsea electricity cable in Bass Strait, Australia. In recent years, in addition to his mediation practice, he also practices as an arbitrator, and he is a member of arbitral panels in Australia and Asia, including ACAICA and AIAC. Mr. Robert is a member of the National Sports Tribunal Australia and Code of Conduct Commissioner of Australian Cricket. Thank you for joining us today, sir, for this session. Moving on to our second panelist for this event, we have Mr. Ankush Mehta. Mr. Ankush Mehta has advisory and litigation experience of over 18 years with focus on corporate and commercial disputes and white-collar crime litigation. He has advised domestic and international clients on a variety of contractual disputes, notably related to infrastructure and construction sectors, employment disputes, real estate, insolvency, and private client practice litigation. He regularly appears in arbitrations, courts, including the High Courts, the Supreme Court, the National Company Law Tribunals, the National Company Law Appellate Tribunal, and other regulatory forums across the country. We thank you, sir, for joining us for today's session. As our third panelist, we have Mr. Pratyush Miglani. Mr. Pratyush is a founding and managing partner at Miglani Verma and Company, New Delhi, overseeing the firm's dispute resolution and commercial litigation practice. In his decade-long experience, he has appeared before numerous arbitral tribunals in a wide host of commercial and investment-related disputes, both international and domestic. He has also appeared before numerous forums, including the Supreme Court of India, various high courts, National Company Law Tribunal, and other tribunals, and for primarily in corporate, commercial, and tax disputes. We welcome you, sir, for this session today. As our fourth panelist, we have Ms. Svenja. Ms. Svenja is a counsel with the Frankfurt
Sorry, have I lost volume of someone?
Thanks for asking. I just wanted to ask the same question.
Yeah.
Yes, even I did. Shambhavi, if you could please fix your internet. All of us can't hear you. I can see the video moving now. I hope the panelists can see it.
Am I audible now? I'm so sorry.
Well, that's the fun
Hope
about doing it online, right?
Right.
Yeah. Ms. Svenya's practice concentrates on arbitration and complex commercial litigation with a particular focus on multi-jurisdictional legal actions with an emphasis on commercial disputes before courts and leading arbitral institutions. Additionally, she's the founder of Digital Coffee Break in Arbitration, which is an initiative to encourage the use of technology in arbitration, and by doing so, it also enhances the accessibility to education and to support diversity in all aspects. Ms. Svenya is also co-host of the monthly Arbitration Happy Hour, an online or hybrid discussion where everyone can join. We welcome you, ma'am, to this panel discussion. As a fifth panelist, we have Ms. Carolina Moro. Ms. Carolina Moro is a qualified Italian lawyer and member of the Udine Bar Association and executive committee member of CyberArk. She is currently based in London and in the process of duly qualifying as a Solicitor of England and Wales. She holds an LLM degree in International Business Law at Queen Mary University of London, awarded with distinction. Particularly intrigued by data protection and cybersecurity related issues, after the experience as data protection legal secondee at Meta, she has just started working as legal counsel and data protection champion within the legal team at Permitive. She is also the member of Chartered Institute of Arbitrators, London branch, and Young ICCA. I once again welcome all the panelists. Thank you for joining us for today's session. Now, I hand over the session to our moderator for this event, Ms. Sanjana Sachdev. Over to you.
Hello again to all the panelists. I am Sanjana Sachdev, a student of New Law College and a student member of Madhyasthata, the Alternate Dispute Resolution Cell, and I will be moderating today's session. It is my absolute pleasure to welcome you all to the fourth and the last session of the international panel discussion, which is themed as Technology in Arbitration Challenges, Avenues, and the Road Ahead. And what would be a better way to end this event, meeting you all virtually to discuss about the technology and how it affects the scope of international arbitration. Before I proceed, I would like to thank our sponsors, LEDX, and our knowledge partners, CyberArk, who have actively supported us throughout the sessions. Let me begin by briefly introducing today's topic to all the participants and about what would be addressed by our esteemed panelists further in detail. Technology has always been integral to dispute resolution during the pandemic and even before the pandemic, as international arbitration involves arbitrators, witnesses, experts, translators, and counsels from multiple jurisdictions across the globe. The use of IT requires various considerations. For example, email and other electronic communications between and among the parties, the arbitrator or the tribunal, as well as the administering body, storage of information for access by the parties and the tribunal, software and media used to present the parties' respective cases in an electronic format, and other hearing room technologies. In light of these considerations, it has become essential to delve deeper into the challenges faced by the dispute resolution mechanism whilst dealing with the digital world. On that note, we have with us today Mr. Robert Heath, Mr. Pratyush Miglani, Mr. Ankush Mehta, Ms. Carolina, and Ms. Svenya. I would now like to request Mr. Ankush Mehta to share his thoughts on the topic for today's session.
Hi, everyone. Good afternoon, good evening, and good morning to most of you. I think it's a privilege to be called here and give a keynote or a welcome address to such wonderful and stellar speakers. So I think this is a big congratulations from my side to Bharati Vidyapeeth and New Law College and of course Madhyasthata I think with that, all of us today, including, nobody imagined a few years ago that we will be, hosting sessions and, exchanging ideas and education through these platforms. I think most of your life now, one can imagine, can be spent, through such mediums, and, you probably don't need to meet anyone. Of course, I'm probably more the champion for saying that, it's more of physical interaction, etc. But I think, talking about just 5 main points to my mind, which come out of my experience, what in terms of the technology in arbitration, the advantages, and sometimes that could be a downside, or that could not have been tested or, coped with. I think the advantages are very clear. It's definitely the need of the hour, right? When you have cross-border disputes or urgent disputes, people are traveling, clients are traveling, lawyers, arbitrators are traveling. It's very easy to hook up a call, just as we have done today, and set up a small hearing, urgent, etc., to sort of close the matter, close the burning issue at hand. The second is flexibility. It, I think, gives all of us the flexibility to take this from the comfort of our homes. If we are holidaying or anywhere else, some time can be dedicated should a legal issue come up for our client. Thirdly, and most importantly, which even the many of the senior judges of Supreme Court and of the High Courts of India have said, it's a huge saver of costs. I think this cannot be underestimated by any stretch of imagination. Travel costs and so many other administrative costs can be reduced to a very large extent, and arbitrations can be conducted as smoothly as it would have been in a physical format. 2 downsides, however, that I see. One is a confidentiality issue, because when we talk about such platforms, we talk about data being centralized in one platform or in one area. Should that be compromised? Should that be attacked? Should there be some virus, that could infringe it? Because I also speak on many cybersecurity and cyber issues, and we know the kind of issues that can happen. So that's one thing. And the second is, I think, more from the practitioner's perspective. One gets the feel of the arbitrator and feel of the judge and feel of the matter when you have the physical presence of the witness and of the other arbitrator themselves. A lot of body language, a lot of sort of feelers that have come out. But I think despite those challenges, one has successfully. I personally have led and argued matters in arbitration and conducted trials. Where one can have end to end have done it in a virtual platform. Just one more point. I think in my personal sort of view, I think arbitration technology and virtual arbitrations are here to stay. And this has been echoed very, very clearly by, as I said, some of the Supreme Court judges who have championed the cause of having virtual arbitrations even in courts. So with that, I hand over the section back to the team, and wish you all the very best. Thank you so much.
Thank you so much for the introduction, sir, and your addressing note. It is indeed true that even though we tend to return to normalcy once the waves tend to cease, arbitration and technology are here to stay, and I feel they are here to stay for a very long time. Fortunately, not the wave which we have had. With this, we would now initiate our panel discussion, and I would like to call on Robert and Svenja to share their views on the fact that there has been this integration for quite some time now, as Mr. Ankush rightly pointed out. However, we did see during the COVID wave that this was somewhat done in a hastily way. On this note, I would like to invite Robert and Svenja and request them to share their thoughts on certain key issues which need to be considered when we are looking at technology and its use in international arbitrations. Robert and Svenja, the floor is yours.
Svenja, why don't you lead off?
Sure. Happy to. Please feel free to interrupt me or add anything whenever I say something. So first of all, thanks everyone for having me. Very excited and very much looking forward to our discussion, of course. When we talk about obstacles, issues in arbitration, and especially the technology factor, I think it's crucial to understand where you stand, because all the obstacles and issues are different for every party in an arbitration. For example, if you are an arbitrator, What you ideally want to have is parties that are aligned in what they want to do, what kind of technology they want to use, if they want to do it online or not. So what you have to consider as an arbitrator, if you have to make a decision one way or the other, is your award enforceable? So one crucial aspect for an arbitrator when using technology is if you are in line with the law, if your award is enforceable. That's different, for example, when you are counsel. What you want to do is, as a counsel in an arbitration, you want your client to win because you want to be on the winning side. So you have to consider, do you want your witnesses to be present? Do you want your witnesses to be only available online? So because then you have to consider, so how do I want to use the technology? What's the best part for me to use the technology? If you are the party, you want to use technology to make it cost efficient. So that's also an issue. Do I save money? Do I win the case? What do I want to do? If you are a witness, that's also different. So, and I'm not talking about experts, because experts, they know what to do. For some, it's easier to be in the room and explain this when showing charts, but they are pros basically when it comes to some calculation of some claims or damages or anything. But let's assume you're just an average, usual witness. And being a witness in a court proceeding, doesn't really matter whether it's arbitration or in a court proceeding, that's pretty stressful. Don't tell this that I'm telling this to you, but my mom was a witness once for a car crash. And in Germany, when they start this, they ask for your name. Okay, so she managed this, saying her name. And then the judge asked her, how old are you? And she's like, I was born that day. There's like, no, I don't want to know your day of birth. I want to know how old you are. And she was just so nervous. And simple questions you're just off. You don't know what to do. And when you do this online as a witness, this just adds an additional layer of stress. Because if you are prepped by someone, said, okay, look into the camera, don't move too much, don't wiggle, don't just stutter, and make sure your internet is working. So it always depends on the position you have in an arbitration, what the issues are you might face in an international arbitration. And this also, it's not really an arbitration proceeding in itself, but just looking at the Wismut now. Nowadays, when we have the moot courts, 4 or 5 years ago, there were nobody really joined online. But now we have different law schools from different countries that would have never thought about joining the Wismut and actually being in Vienna just because for financial reasons, for example. Nowadays, they have the chance to join. And their issues are, do we have stable internet connection? How do we get the research? So the questions, the difficulties in technology vary on the position you have in an arbitration, and the position you have in your professional life. So this basically sums up what I think are the kind of key issues. And I know there are data privacy issues, but I know that Carolina is definitely the expert in addressing this.
Svenja, can I pick up on a couple of your points and offer my own perspectives? At the height of pandemic lockdowns in my jurisdiction, and they were Shanghai-like, and I don't say that lightly, we were confined here for nearly 300 days at home. I ran a long arbitration and I moved into a service department because for our European witness phase of the hearing, it was incompatible with family life at home. In my suburb, the National Broadband Network of Australia pipes in internet through copper wires. One suburb over, where I was in a service department, satellite. And 7 p.m. Australian time, whatever that was in Norway and Sweden, where our experts were, at 7 p.m. here, the post-dinner Netflix surge started. And the poor people in Brighton who didn't have a massive internet dongle that I had and my solicitors had given me to use, kept cutting out. And you can't win your case if your internet cuts out. You just can't persuade the tribunal that you deserve to win or your witness is more credible than their witness. So you've got to get your technology right and you've got to test it. You've got to have a good document management system. And there were parts of it that I loved. You didn't have endless conferences with the clients at the end of every day. You had the 15-minute allocated breakout room. Magnificent. The poor old arbitrator, retired judge, magnificent person, great lawyer, but struggled with the technology. And his PA would come in and manipulate Zoom for him. But in the end, we got there. So, for putative arbitrators out there, get on top of the technology, because I'm sure in the future that if you want to be appointed, that's going to be a critical thing in terms of criteria. And witnesses, if I can follow up on that very briefly, there's always a bit of cheating, people putting up post-it notes on the screen and trying to read from them. We had a famous example in Australia a year or two ago in a commission of inquiry in relation to a gambling license and fit and proper person issues. And a very decorated company director couldn't actually comment on the nature and content of director's duties. And it became very obvious that he was reading from a printout taped to the wall behind him. You're going to get a bit of that. But as counsel, as arbitrator, you can deal with that. So they're the sorts of issues. Good, it's great. It's the way of the future. I feel a little bit, though, for Arijit and his comrades, because if they're doing online hearings all the time, they're not hanging around outside the practice court in Mumbai, Delhi, Melbourne, and they're missing out on the interactions that we have before and after court hearings, which were critical for me. And Pratyush, I can see you nodding. I think that sort of experience of meeting people, talking, trying to negotiate a set of orders before you go in for a procedural hearing or a directions hearing, that's critical. So I hope we don't sacrifice that.
Thank you very much, Ms. Svenya and Robert, for sharing your thoughts on the same. As both of you rightly mentioned about the use of information technology in arbitration, that has driven several questions on confidentiality, data security, unvaried cause, lack of data handling skills, and many other reasons. On this note, I would like to invite Mr. Pratyush to share their thoughts on how can we use the benefits of technological advancements while managing the procedural drawbacks that may potentially arise. Pratyush, sir, please.
Thank you, Sanjana. Hi, it's a pleasure to be here. So I wouldn't necessarily use the word drawback, because while I think, when the pandemic started, at least for us, while, we were doing an arbitration and we were supposed to fly out to Singapore for final arguments in an arbitration, and the lockdown happened, certainly the matter was adjourned for a couple of months, but for us to even change the mindset from, say, doing a physical hearing, doing the evidence in person, to doing it remotely and online, it just required a mindset change, because the initial thought that we had that, oh, we'll not be able to do it, I think once we went through the process, we found it to be very smooth. And another thing that I must say is that as the arbitration community, the institutions, as well as international organizations like IBA, I think everyone has come together to kind of work on and remove these challenges by adopting to new technologies, new procedures, and ensuring that the challenges, say, in terms of collection of evidence or use of technology, or having so technology has always been a part of the arbitration even prior to the pandemic, which is evident from, say, live transcripts and hearing room technologies. But I think the emphasis has become more post the pandemic. And so long as a party's right to a fair hearing or the opportunity to present its case is not taken away, I think technology is certainly, going to help in terms of minimizing the costs, minimizing, the carbon footprint that we have, ensuring that, more juniors are able to attend the hearing if we are not traveling all together to a particular destination. So in that sense, I think, it has really come a long way. Talking about, say, domestic arbitrations, which are mostly headed by tribunals where these are retired High Court or Supreme Court judges, it's been very welcoming to see that they have been able to change, after having, going through like physical files over their 40 years of experience and, switching to online hearings. So I think as a community, we have really worked together to ensure that this process moves on forward, because there is no other option. This is probably what we learned in the pandemic, that we'll have to all change our ways of working together if we are to, move ahead. So I would certainly say that technology has really helped in terms of increasing the access of arbitration to all.
Thank you very much for the same. And I do agree, even we participated in the race twice. A lot of other teams did, and I was reading an informal survey where they did mention that as compared to when the rounds would generally happen in Vienna or Hong Kong, as compared to what happened online, there was an additional participation of about 70 to 80 teams. So yes, that's always a good experience. But yes, I guess one has to balance the ins and outs of that. With this, I would like to come to the next point of discussion, for which I would like to invite Svenja and Carolina. And our discussion would now revolve around the numerous guidelines which have been there. For instance, the one by the ICCA, the most recent one by the Chartered Institute of Arbitrators. What I wish to understand is, what are your firstly thoughts on these guidelines? And secondly, how can those be brought into practice, considering the important fact that guidelines are non-binding in nature and it's generally up to the parties to adhere to those. Svenja and Carolina, the floor is all yours.
Svenja, I don't know if you want to start or I can go.
I already started, so now it's your turn first, please.
Okay. Well, so first of all, thank you very much and congratulations to the organizers, and thank you for having me. Yes, as it was already pointed out, technology was already there in the field of international arbitration, but the outbreak of the pandemic and the fact that the whole business went online somehow forced everyone to realize that cybersecurity and information security issues and technology in general is not something that only for the IT experts to deal with, but somehow everyone had to get used to it. And this also explains the surge of guidelines that were issued, especially at the beginning of the pandemic and following. And it's not just casual that the first guidelines were focusing especially on the virtual hearing, on the conduct of virtual hearings. And I'm thinking, for example, of the Civil Protocol on video conferencing in international arbitration, and the ICODR, video arbitration guidelines, and even the CIAB issued at the time a guidance on the conduct of virtual hearings. And then, of course, we had two, at least I would mention two more comprehensive guidelines on cybersecurity in particular. One is the IBA guideline on cybersecurity that was supposed to be direct to law firms in particular. So it doesn't focus on international arbitration, but provides guidance to lawyers and law firms, and that can also be applied to the international arbitration field. And the other one is obviously the 2020 Cybersecurity Protocol issued by ICA, New York City Bar Association, and the CPR. And that is perhaps so far the most comprehensive and practical piece of advice that we have available. And then the most recent guideline from the CIAB, it's a framework guideline on the use of technology that you mentioned, Arijit. This piece rests on this amount of available guidelines. What I found interesting is that this is a framework guideline, so it's general in nature, and it is divided in two parts. So a first part is about principles. So it tries to address, it tries to understand what the powers of the arbitrators are, the powers and duties, and also the purpose is to ensure fairness and proportionality in the use of technology. And then the second part focuses more on practical guidance and try to provide best practices in terms of what concretely can be done by arbitrators in the conduct of, in the use of technology very generally, and also in the conduct of virtual hearings. So this framework guideline, I would say it builds on the already existing and available soft law instruments. And what I noticed, but I would like to discuss about this with all panelists actually, is the emergence of some general principles about this cybersecurity, information security in general in the international arbitration field. And I would say we have at least 3 of them. So the first one is that ensuring an appropriate level of cybersecurity is a responsibility of all participants, as the exchange and the sharing of databases makes it so all stakeholders in an arbitration, to different extent, they are interconnected somehow, and breaches, in the chain, they say the chain is as strong as the weakest link. So everyone has a responsibility to ensure that the arbitration is conducted safely and efficiently. And then the second point is, as anticipated by Svenja, that of course, cybersecurity issues are also closely intertwined with data protection issues. And ensuring the security of data and a secure use of technology in arbitration is not only a way to enforce the principles underpinning the international arbitration field. I'm thinking about, for example, confidentiality and due process, but also that they also comply with mandatory data protection laws, as these usually also mandate a certain level of security of data. And the third principle would be the fact that cybersecurity, information security issues should be addressed very early in the proceedings. And the big question is, who should take the lead in this? So the existing soft law instruments and the updated arbitration rules, I'm thinking of, for example, Article 30A of the ICIA rules, they seem to pose this duty on the arbitrators. But the question is whether this is the best choice or not, in the sense that arbitrators are not themselves tech experts, and they may not be usually, and they may not be, up to date with, or even able to understand all the existing risks and which measures would be appropriate, and even which are the currently existing alternatives. They do not have generally an IT department to back them up, as counsels may have from big law firms or even sophisticated parties, for example. And so I do recall there was a survey by Brian Cave, Leighton Paisner in 2018, I think, and the majority of the respondents actually said that this should be an issue to be dealt with by the parties first. And I found this interesting. And then, of course, there is another line of thought that says that this should actually be responsibility of the arbitral institutions, so that if the arbitral institutions align on certain standards, that would make it possible to actually, reach a wider amount of arbitrations. So, of course, we would still have assessments on a case-by-case basis, but at least we could ensure a baseline level of security across the field. And I would like to know what Svenja thinks about this, because I know it's kind of controversial.
Well, thanks so much, Karolina. That was very interesting. And I do love controversial thoughts, and I'm just putting one out there right now. Well, we have heard, and that's true, it's just a guideline. It's not binding. Who's responsible? And what is arbitration about? Arbitration is about two parties agreeing on procedural issues. So why should it be the arbitrator? Why should it be the institution? Shouldn't it be the parties who are responsible to ensure the data privacy? Of course, there are guidelines, and I think the guidelines are very helpful. So when you have the guidelines as an arbitrator, you can just check the box and go through it. And you have a certain responsibility to guide the parties through what is possible and not. But when I represent a party, I think it's in the party's interest to have the best security possible. And when I have a case where I really need data privacy because this is like really, really confidential information, it's my responsibility also to find an arbitrator who I think is capable of understanding the difficulties in data privacy, in confidentiality because of transfer of data. So yes, it might be the institution, but I think the institution and also the arbitrator, they only give a kind of framework, whereas it's the party's responsibility to ensure that everything is in order. So this just basically adds to what you said. But I understand that from a party perspective, like, okay, so that's our arbitrator, he has to give us everything. I think it depends on what, I understand both sides, but I think it's for the arbitrator, it's important that his case, his award will not be overturned because he or she made some mistakes. But it's even more important for the parties that the confidential information stays confidential, and they have to do something. And the guidelines proposed by institutions, by CIRAP, by ICA, by others, they are always helpful, and you should everyone who's doing an arbitration should read them and see what works for the individual case at hand, because also every case is different. So some cases, they require very high security systems. Some cases, you can just use less of all the guidelines that are there. Some guidelines fit, some don't. So it's always a pro and con, and reading the case, reading the case law also in the different countries, being up to date with what's happening. So this is what I would add to this. But I'm happy to hear Robert's thoughts, for example, on this.
Thanks, Svenja. I will certainly need someone who's competent in terms of arbitrators, someone who's competent in terms of dealing with things. I agree entirely. But the parties have to really take the mantle here, don't they? Too often they sleepwalk into the general counsel doesn't liaise with the IT team. No one has a handle on the extent to which information is truly confidential and requires protection. And so often it's the solicitor or the lawyer who's pulling all of that together and marshalling all the things that need to be done. But so I think you're right. The parties really need to take responsibility with the encouragement of the lawyer who's herding the cats. And then you have to take steps and then come back to Carolina's point, agree early on the protocol, reach out to the other side and take responsibility.
Well, thank you so much for sharing your insights on the same. And now we would move on to the segment of a few questions which we have received so far. And the first question goes as follows, is that as the panel rightly pointed out, as the practice and the technology and the entire procedure is more concerned with party autonomy. What would happen if, for instance, two parties could not agree on a common set of technologies to use? How should the rules adapt certain measures to step in and assist the parties in such situations? This question is open to also. If each one of the members could maybe add their thoughts to it, I'm sure the audience would have a lot of takeaways from it.
I'll just jump in and go first. So if you have to make a decision as an arbitrator, you always have to consider the capabilities of both of the parties, because you have to make sure that the process is still fair. So you cannot have one decision on technology knowing, or at least being concerned, that one party simply cannot live up to the standard you set. So you have to make sure that each party has been heard. The due process is important. The fairness is important. So at some point you have to make a decision as an arbitrator, because that's why people appointed you, that you make decisions if the parties cannot agree. But you always have to consider the individual positions when doing so.
Just adding to what Svenja said, I think, the tribunal has that discretion, after taking into consideration the circumstances and the technology available to the parties, to ensure that whatever platform is being used, does not impinge upon their right to a fair hearing. And once that discretion is exercised, I don't think it should be open to a party to say that, okay, I'm going to resist enforcement because Cisco was used and not Zoom. So I think it should be left to the tribunal, with the aid and assistance of the institutions, of course.
Yeah, thank you so much for sharing your insights on the same. We have another quite interesting questions which concerns witnesses. And it was discussed, we did discuss it a couple of moments ago, that witnesses may be trained by way of putting chits or putting boards in front of them. How do you see metaverse coming into this? Because when we speak of metaverse, you just have the person wearing the virtual gear. They are the only ones concerned into the hearing. So what potential does metaverse have when it comes to witnesses in international arbitration?
I must confess, I'm not that great on the metaverse stuff, so I'm going to defer to others to talk about this in the first instance, at least.
I'll just go. Not that I'm an expert in the metaverse. I know that Lizzie Chan, she is definitely an expert on the metaverse. So she would be the best person the best person I know to address this question. But I think the metaverse is something that is currently still evolving. From what I know, it's okay at this stage to host discussions, to meet virtually. But my experience with the metaverse is not that I think you could actually have witnesses, for probably two reasons. One reason, the metaverse, you have an avatar. Very often you have this avatar, and if you speak to an avatar, you lack the facial expression. And in that case, I could also have just an audio call. I don't really need metaverse for witness if I want to see the facial expression. I personally prefer, if I speak to people, to be in the same room with them, to see how they act, to kind of feel the room. And I think video conferencing works for some hearings, and it's the best we have at times where we couldn't do it otherwise. But the metaverse and speaking to an avatar, I'm not convinced at this point, because of the technology not being as sophisticated as I wish it would be. This is definitely coming, and this is probably at some point we will have holograms and sitting in a room with holograms. Just let's fast forward 15, 20 years. So this is going to come at some point. But these are my thoughts about the metaverse. Slightly open, definitely open, but not convinced at this stage. I hope that was clear what I tried to say here.
Well, that indeed was. And we have another few series of questions, and I think we can take this one, which concerns what rights, including access to information, does the service provider have? Rather, I believe it's what the contestant means is what obligations does the technology provider have, let's say in terms of the GDPR, or let's say any other European law, whenever parties submit to their technologies, or they are outsourcing the use of technology through a third-party provider.
I can briefly jump on this. I would refer to the GDPR also because, of course, it has, as we all know, an extraterritorial application. So the GDPR is not only relevant in Europe, let's say for European entities, but also for entities outside of the EU who are processing personal data of natural persons residing within the EU, offering services, including this kind of online platforms and technology. So main obligations, a lot of obligations, but the main ones that are relevant today are, of course, the security. So the obligation to, it's Article 32. Sorry, I'm just reading it also because it somehow reflects what we were saying before about the what level of technology we can expect from the parties and other stakeholders as well. So taking into account the state of the art of technology, the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of varying likelihood and severity for the rights and freedoms of natural persons, the controller and the processor, so we would say the service provider, shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risks. So once again, it's left to the assessment of the parties involved. So this is one thing. So cybersecurity is also important because, following the guidelines somehow supports the compliance with data protection laws as well. And then, of course, the GDPR recognizes some fundamental rights to data subjects, so to the natural persons whose data are processed. And these are, there are a certain amount of them. So the first one is the right of access to the information, which also includes the right of the person to know information about the processing. And this is usually done via the privacy policies that we see every time. Then we do have a right to rectification of the personal data that are processed, the right to erasure, of course, under certain conditions, the right to restriction of processing as well, the right to data portability. So the data subject has the right to have a copy in an intelligible format of their data that are processed, and also they have a right to bring those data to other processors or service providers as well. The right to object the processing, and the right not to be subject to a decision based solely on automated processing. And then, of course, the other side of these rights is the obligation of the service provider to be able to make sure that his user can actually exercise these rights. So I was curious about it, and I just gave a look to Zoom. How does Zoom enforce these rights to the users? And if you go to the data privacy, to the privacy policy of Zoom, they do have a module to compile. So they just mention if you want to access your information, you go to this module and you fill in, but they actually use it for all the rights. So it's a very basic way, but they make it available for people resident in the EU and European area and such.
Yes, with this, thank you so much for explaining and focusing on Zoom in particular, because as I understand, Zoom and Cisco are the most widely used platforms, and I'm sure that has given our audience a brief understanding of how they may go about it. Another question is that how serious and probable are data breaches and cyber attacks, and how can parties make sure they are taking all the necessary steps to at least prevent those? Because as I understand, they cannot negate it completely, but at least they can take a few necessary steps to make it sure from their end that things don't go south. So yeah, this is again open to everyone.
I might get the ball rolling. There's been a couple of controversial things in Australia within an investment state dispute arbitration between Australia and East Timor in relation to the Sunrise gas field, which is in, I think, between the northern part of Australia and East Timor, which of course is part of if I can say this not in a geopolitical way, the Indonesian archipelago. Real problems with alleged tapping of the cabinet room in East Timor by, anyway, I won't go into it, but it's a problem, I think. That's all I really want to demonstrate at that higher level. Whether it really is a problem or should be a problem at the lower level, domestic arbitration is a matter of debate. But that brings us to that great Queen's Mary University ICA paper on cybersecurity. I'm sure you've all seen it. Please Google it. And have a look at it, but it's excellent. I wasn't aware of it until I was preparing madly for this webinar, if I can make that confession. It's excellent and does discuss the question of proportionality and forces the people who read it and participants in arbitrations to consider whether they really do need to use the whole box and dice for their arbitration.
Thank you so much for sharing your insights, and I'm sure I'm going to put it in the YouTube live link or even the chat box for all the attendees so that they can access that paper. And as I can see that we are coming towards the conclusion of this session, I would request each one of our panelists to just share in a couple of minutes as to how can we see other possible prospects for use of technology in arbitration, and if as technology is here to stay, how do we make peace with technology, if I can put it that way?
Don't be afraid. So what people think, because I have a digital coffee break in arbitration, that I know technology, which is not true. I need technology to be easily accessible, and it needs to be easy for me to understand. I am not a pro when it comes to, I'm looking like this, I'm pressing on off, it's not working. So the first thing I do, if something is not working, I'll just restart and hope it works. So this is my go-to move. And then I will probably just hit against the table a few times, and then I call the IT. It's not working, I don't know why. I try to copy it. So having said this, technology is going to stay. And the way on how I approach technology, I'll just give it a try all the time. If it's too complicated for me, I don't like it. So I pick the tools that are the easiest way for me to understand. And this is what's going to happen. Technology is going to be easier and easier every time. The more you try it, the easier it is. I remember my very first webinar 2 years ago. I'm not sure if some people realize it was Sneha Ashtika from Musmundi. And it was the first Zoom webinar I did. And everything went wrong that could possibly happen. So I was in the Zoom link, and for whatever reason, nobody could hear me. So what her CEO did is, I'll just kick her out and she can dial in again. The thing is, if you kick someone out, this person cannot go back in. So I was supposed to talk and I couldn't go back in. And we panicked. And then Sneha called me on video call WhatsApp and was holding her phone into the camera to just, people could hear me during her camera. So I'm glad it was the very first time it happened, because now, like, whatever happens, it will work out somehow. So always just give it a try. Don't be afraid. If it's not working, you're not the first person. You will not be the last person. It's going to happen, and just give it a try and use the tools you feel most comfortable with, but also be open to try new tools, and then decide maybe this is not for you, but don't be afraid. So that was my 2 cents.
Thank you. And that, in fact, was a very good session, because I remember I was a part of it, and that was indeed one of the unique things I noticed during the pandemic.
Yeah, sorry, I just wanted to say that I feel you, Svenja, because I'm also part of CyberArb, which actually the purpose of it is literally just to try and make technology more comprehensible to lawyers, people with a law background who really have a very, I would say, limited knowledge of technology, just because there is so much to know and so much to understand that requires an expertise as well. So my suggestion would be to stay up to date somehow, just because technology keeps developing, keeps evolving, and cyber threats follow, unfortunately. So the idea is, of course, yes, I totally agree. It has to be simple. But at the same time, we also need to be aware of what's going on, what the risks could be, and just use common sense. Sometimes it also just goes down to it. Yeah, so of course, I would recommend CyberHub website and our LinkedIn. Also considering that CyberHub is knowledge partner, I'm just doing a little bit of advertisement. But it's really helpful, I believe, to me at least. I'm learning a lot by joining their group, and yeah, and hopefully we can be useful and helpful. Thank you.
So, I mean, I'll just use Michael Dell's words. He says, change or die. So unless, we change with time, I think, we'll be left behind. And people who are adopting the technologies, I think they will get more and more cases to appear in. So in that sense, I think we really need to up our game and just move ahead with the times. Having said that, I would want to share a nugget of information, which I was just reading a couple of days ago, that, the kind of impact technology has in respect of arbitration and carbon footprint. So Herbert Smith did a study where they said that, out of the carbon footprint that comes out of an arbitration from travel, 98% alone is dedicated to your air traffic. And the kind of trees that you would require to offset the carbon footprint would be 10,000. So just imagine that that's the mid-size arbitration, they're comparing to, and the kind of impact it has on the environment. So I think as the arbitration community, I think we seriously need to consider that wherever there are low value cases or cases which can be decided only basis documents, we must insist on online arbitrations alone.
That which I'd wish to add is this: give due respect in the future to technology-enabled legal solution companies. They're excellent by and large. We've heard about some already, but if I can use another example, and I have no connection with them, although I've appeared in arbitration hearings that they've conducted, Epic and organisations like that. If it's a serious dispute, that is a dispute of substance, if there's a lot at stake, even if it's not a huge dispute, you want to make it easy for the tribunal, you want to make it easy for your witnesses and your lawyers, then clients need to be encouraged, which is really an extension of what the other speakers have said, to make a go of the technology and to really get hold of it. So don't discount the importance of an Epic or an organisation like that. Actually embrace it and move on. It's a pleasure. It's like driving a very fast, expensive sports car. If someone throws you the keys, lots of screens, split screens, and management of confidential information, it's all fantastic. So I think that's the way of the future.
Thank you very much to each one of you for sharing all your insights on the last point of discussion. And as I sense that we are edging towards the conclusion of this wonderful panel discussion, I would now like to hand it over to my co-moderator Sanjana, who would proceed with the vote of thanks, and then we'll officially conclude this session. Thank you.
On behalf of our university, college principal, as well as our faculty coordinator, Ms. Shivangi Sinha, I'd like to extend my heartfelt thank you to all the panelists for taking out their valuable time and engaging in this informative session. I'm sure all the participants who have joined us through our YouTube live would have gained a lot from your knowledge. I'd also like to thank our knowledge partner, CyberHub, as well as our sponsor, LEDX, for supporting us throughout. Thank you very much. I hope we could connect with all of you sometime again in the future, and hopefully not virtually. We are very excited to host you sometime in the future in our university as well as college, and we could give you a good guide to our country as well. Thank you very much, everyone, and have a good day.
Thank you.
Thank you.
Thank you.
Oh,
Thanks,
sorry.
everyone.
Before we end, I'd like to request for a screenshot if everybody is comfortable with the same.
Yes.
Maybe on the count of 3. 3, 2, 1.
Thank you so much. And yes, we do hope that we get to meet in person sometime, and we can have an in-person panel discussion soon. Thank you so much, and have a great evening ahead.
Thank you.
Thank
Bye.
you.